With respect to those who formulated those legal decisions, I would say that that is going to be more of a decision for the Attorney General within the parameters of various laws, and I don't want to prejudge that.
That's going to be more of a decision for the Attorney General, he says. Whatever the president has said about what he prefers about criminal prosecutions of Bush administration officials for torture, it's not really his call to make. The Justice Department is an independent agency that makes its own calls about how to enforce the law and what actions or suspected actions warrant criminal investigation. The law, in other words, in America, is bigger than the presidency. In addition to the Justice Department now considering steps toward prosecution, the decision to release the Office of Legal Counsel memos about torture has had one other major ramification thus far, and it is this. Government officials who knew about the interrogation program, but who were sworn to secrecy as long as the program was still officially classified, they're now free to talk about it. And because of that, we have new major news to report. In May 2005, Condoleezza Rice's counselor at the State Department, Philip Zelikow, gained access to the memos we have now all seen since they were published last week. Supposedly authoritative legal analysis, those heretofore secret legal memos we've all now read, they said that those techniques were okay, according to U.S. law. We are now learning that competing advice was distributed inside the Bush administration that said, no, that analysis was wrong. According to Philip Zelikow, writing at the website of Foreign Policy magazine today, quote, "My colleagues were entitled to ignore my views. They did more than that. The White House attempted to collect and destroy all copies of my memo." Joining us now is Philip Zelikow, former counselor at the State Department, a trusted advisor and deputy to Secretary of State Condoleezza Rice. He also served as executive director of the 9/11 Commission, and he's now a contributor to Foreign Policy magazine. Mr. Zelikow, thank you so much for taking time to join us tonight.
Glad to be here.
First of all, let me give you the opportunity to correct me if I have mischaracterized anything. Is what I have said about your involvement in this issue thus far, have I accurately characterized it?
Yes.
Okay. So you first saw these Office of Legal Counsel memos in 2005. What was your reaction to the legal reasoning in those memos?
Many years earlier, when I had been a law student and had been a practicing lawyer, I had worked actually on issues of treatment of prisoners and that whole body of constitutional law. So when I saw the memoranda, I was struck by the fact that even aside from the policy problems, the legal reasoning seemed deeply unsound to me, and I wasn't sure that the president and his advisors understood just how potentially questionable and unreasonable many lawyers and judges would find this reasoning. And so I thought it was important to just say, hey, there's another view here of this law, and a lot of people would regard the views in these memos as, to say the least, outliers.
So when you say that judges might see it, we suggest judges are one of the audiences that might not be persuaded by the reasoning in these memos. Were you thinking ahead to the purpose for which these memos were drafted, which was essentially, I mean, it's hard for those of us outside of government to sometimes understand what an OLC, what the purpose of an OLC memo is, a defense in case people were accused of acting illegally in ways that were described in those memos. Is that what you were thinking of?
Yeah, Rachel, perhaps just a little bit of background to put this in context for your viewers. America has fought a number of wars in our history, including against unconventional enemies. This was an interrogation program, however, for which there is no precedent in the history of the United States. We've never done a program like this before. So where the administration is moving into uncharted waters, they're clearly doing things that folks know are as legally questionable. That's why these opinions were requested, because there were questions about whether this sort of conduct was lawful, since it was unprecedented. So here the Justice Department is coming down and saying, well, look, this is a murky area of the law, but here's what we think you're allowed to do. Now, whether it's a good idea to do it is another question. Whether it's moral is another question. The question before them was, is it lawful to do this? And the Justice Department has the job of giving authoritative guidance for the executive how the U.S. law should be interpreted.
And the memo that you wrote, the document that you wrote that you've described today at the website of Foreign Policy Magazine, essentially said that they got it wrong as to what you are allowed to do under U.S. law, that their reasoning was flawed. It didn't take account of the relevant case law, for example, that they should have called on to prove their point. Is that accurate?
Yes, that's accurate. Now, look, I'm just one point of view. I looked at their point of view, and it didn't strike me as a mainstream or reasonable way of construing the relevant standards of treatment, of the definition of terms like cruel, inhuman, or degrading.
I have to ask, given your description of how you felt about these memos and the actions that you took, some of the other reporting that other people have said about you in terms of your role in the administration at this time, I have to ask if you ever contemplated resigning over this issue, if you felt quite strongly about it.
No. You have to understand, this is a battle that had months beforehand and went on for months afterwards. This is Chapter 9 of 32 chapters. And actually, by the end of 2005 and on into 2006, we were achieving major changes. We were achieving major changes in what the standards would be that would govern what we were doing, major changes in what the CIA was actually doing in the sites, and important changes in the way we were beginning to talk to our allies about these problems and move towards bringing these people out of the black sites and into the light. The lawyers, the Red Cross, all of that. That's a decision that we achieved in 2006 that was made by President Bush in 2006. So we were in a process of working this from the inside while people like Senator McCain were doing really important work on this issue on Capitol Hill. Supreme Court delivered a very important opinion on this, Hamdan versus Rumsfeld, during 2006. So we were part of a combination of forces that was trying to move our government in a different direction, to turn the page and get this moving in a healthier direction. And I think we began turning that corner in 2006.
I feel like I'm starting to think in the way that you approached this, just from talking to you now and from what I know about your actions, but there is one thing that still doesn't resonate for me, and that is in 2005 when you found out that this memo that you wrote, which said this Office of Legal Counsel attempt to say that things like hanging people from ceilings and sleep deprivation, these other things is illegal, it's wrongly reasoned. There's them saying this is legal under U.S. law is an inappropriate legal understanding. It's an inappropriate understanding of U.S. law. When you were collecting your memo with that criticism in it and destroying it so there would be no evidence of it, at a time when you knew that they were going to carry out those techniques, which you must have believed were not legal since you had seen the legal rationalization for it, it's hard for me to believe that you would not think about resigning or blowing the whistle or saying publicly what was going on at that time.
It was my job to fight this with every ounce of energy at my disposal using the legal means in front of me. And frankly, that's the same way they should have approached their job, is work within the institutions you've got, the institutions our country gives you. They weren't committing an act of obstruction of justice by trying to destroy copies of the memos, and they did not succeed in destroying all the copies of these memos. Just because they disagree with an alternative view doesn't mean that my view was right. But it was important to register the fact that, hey, folks need to understand, if they didn't already, a lot of lawyers might believe that this is a radical, indefensible, unreasonable interpretation of the relevant law. They heard that argument. They chose to move on. We continued the fight to change the policy, and ultimately did change the policy with help from Congress and the courts.
One last question for you. If members of the National Security Council Principals Committee or Deputies Committee did say thumbs up to specific techniques like waterboarding or like hanging people from the ceiling that were mentioned in those Office of Legal Counsel memos, and they said thumbs up to that on the basis of there being legal authorization in those memos, do you think those officials committed a...
I'm going to obey the same advice I would give to President Obama, which is when people argue that crimes have been committed, our country has institutions to sort this out. One of those institutions is the Department of Justice and the Attorney General. President Obama ran on the platform that we're going to depoliticize the Department of Justice. Well, let's do that. let's refer all those questions to the Department of Justice. You have a question about whether these people will be prosecuted. The Department of Justice is looking into the matter. The Attorney General is looking into the matter. They'll sort this out the way they sort out other allegations of crime, and let's just see where it goes. And that's my approach too, is I'm not going to rush to judgment. I'm not going to try to prejudge or politicize the issue. It's important folks understand there's another point of view and was another point of view on some of these matters. Now let our institutions do their job.